Now a hearing on whether or not to renew the independent counsel law, which expires in June. Today, a House Judiciary Subcommittee heard from two former attorneys general, William Barr from the Bush administration and Benjamin Civiletti, who worked in the Carter administration. Also testifying were legal scholars. Pennsylvania Congressman George Gekas chaired the 2.5-hour hearing.
The time of the recess having expired, with the presence now of the gentleman from Ohio, Mr. Shabbat, we will begin a truncated form of this hearing by accommodating opening statements by the members, and thus when the time comes to hear from our witnesses, it may be that 2 or 3 others of the panel may have arrived. In either event, we now recognize the gentleman from Ohio, Mr. Shabbat, for an opening statement.
Thank you, Mr. Chairman. I'd like to thank Chairman Gekas for holding this hearing today. And I'm looking forward to working with my colleagues on both sides of the aisle on this very important issue. The last time we met, we listened to the Deputy Attorney General Eric Holder describe the Clinton administration's newfound disdain for this statute after they had fought hard to have it reauthorized back in 1994. It seems that many individuals and organizations have found themselves in the same position. We will hear later this morning from Philip Anderson, President of the American Bar Association. The ABA was one of the principal proponents of the creation of the Office of the Independent Counsel back in 1978. Today, they will call for the statute's expiration on June 30th, or at the very least, request that Congress narrow the prosecutorial authority created by this law. Most share common concerns. There are serious questions about an independent counsel's accountability, as well as the unlimited cost of these investigations and the open-ended mandate created by the language of the statute. Today, I'm most interested in hearing recommendations as to where we go from here, what we should do next. Many, including the American Bar Association, have suggested that the special counsel provision, which was recently used in the Whitewater investigation with the appointment of Robert Fisk, is an acceptable alternative. This statute was also used during Watergate and resulted in the conviction of 2 attorneys general, the vice president, and numerous high-ranking executives. The consensus at that time was that the system had worked well. There seems to be no such agreement about the current independent counsel statute. I'm eager to hear about how the special counsel provision would fill the void left if we allow this statute to expire. Is the current special counsel statute adequate, or will it need to be reworked to add additional safeguards? I'm not, of course, saying that it is a foregone conclusion that the independent counsel statute will die this summer. This subcommittee still needs to explore the possibility that the existing law may be revived by making significant changes. I look forward to hearing the differing views on this issue over the course of these hearings. And I'll yield back the balance of my time. Again, I want to commend the chairman for holding these hearings.
We thank the gentleman. The gentleman from Ohio has set the tone for the preparatory remarks to be made by most of the members in anticipation of this set of testimonies and what is yet to follow in the search for a solution to the problem posed by independent counsel. We recognize now the gentleman from Massachusetts, if he should care to make an opening statement.
Well, I won't make an opening statement, Mr. Chairman, but I really welcome these hearings. I'd like to make an observation. I think that these hearings provide us, in addition to an examination and a review of the history and our experience with the independent counsel statute, an opportunity to examine the role and the function of the prosecutor within our justice system. So for those who view the independent counsel statute and our experience with it in a negative fashion, I think there's a silver lining. I would suggest to them that there's a silver lining in this cloud, because it does present that window of opportunity to examine, as I said, the prosecutorial practices which have caused so much concern. And again, I'm not referring simply to the investigation being conducted by Mr. Starr, but during the course of the past 20 years, because of the high-profile nature of these cases, the American people have seen the justice system, I think, in a different light, and the role and the function of the prosecutor. Many have said, and I think correctly so, that the techniques used and utilized by independent counsel, while disconcerting and upsetting to many, are not necessarily different than those used and utilized by all prosecutors. And I guess part of the question is, for policymakers and for members of Congress, is do we want to change the standards that apply to prosecutors, specifically federal prosecutors, since that is our jurisdiction? And I would respectfully ask the witnesses to think about that when they make their own comments. So thank you, Mr. Chairman.
The gentleman yields back the balance of his time. As we have noted, this hearing is the second that we have now conducted in this important issue. The Senate itself has already engaged in several of the same types of hearings, and more will follow both in that chamber and in ours. One thing that strikes me, and this concern that I'm about to enunciate, was one that I made clear to Eric Holder, the Deputy Attorney General who testified last week as to the position of the Justice Department, which was clearly one that would end the statute and its effectiveness as of June 30th of this year. The concern that we expressed at that time, one which still runs through my veins, is what happens in July of 1999. We will have no statute any longer to look to for the purpose of arranging a solution for conflicts of interest in the executive branch. On the other hand, we do not have before us some concrete vision of what the Justice Department itself might do within its own mechanisms, be it within the public integrity section or other specially created organs that might arise from within the Justice Department. And I see a tremendous hiatus forming over the Capitol with respect to dealing with allegations of wrongdoing on the part of high public officials. This is very worrisome to me. Apropos to that, I want the members to know that we, as they will recall, have urged Mr. Holder to report to us within 30 days of a succinct and specific plan on how reorganization within the Justice Department or focus of existing mechanisms in the Justice Department will deal with that concern that we've expressed, and that the country will know and have confidence that once this statute should be phased out, as most certainly it seems from all indications, what will be in its place which will gain and earn the confidence of the American people to deal with those problems. What we've done as an addition and as an addendum to the request we made of Mr. Holder is to outline a letter which we will be forwarding to the Attorney General, reminding them of what we requested of Mr. Holder, and also to suggest that they consider certain elements that we feel might be important in fashioning the new mechanism that they foresee for the office of for the Justice Department. I say these things to prepare our witnesses for consideration of these very same subjective themes for the purpose of their deliberations as they give us their testimony, and for the questions and answer period that will follow the presentation of their testimony. The letter that we have proposed to send, and which will circulate to the members of the committee for their co-signature if they feel it is cogent and worthwhile, has as its key features our request that the response from the Justice Department should consider the following proposals which we feel should be considered by them. Number one, elevating the individual heading the Public Integrity Section to an Assistant Attorney General subject to Senate confirmation. That's just one idea. I see some trouble in my own mind on asking for a mechanism that would require the confirmation of the Senate. Two, granting that individual a fixed term that would extend beyond the electoral cycle. Why? Because we want to try to guarantee as much as we can a sense of independence of action on the part of the chief of the next investigation of some high public official. Three, providing for the removal of such individual only for good cause. And four, and this one I think is sort of the best of the lot, and one that we should be able to use some creative legislating. The creation of an advisory body or commission whose task it would be to work within the Department of Justice to certify a pool of attorneys from whom special counsel would be chosen. I don't know exactly how that works. This is just ephemeral in our minds, but this too, if we had such a pool of individuals who could be drafted for these positions as allegations arose, might further guarantee a sense of independence on the part of the work of the next special counsel, whatever name we apply to him, for allegations of wrongdoing in high places. So the work of this hearing and the work of this committee is not relegated to simply a set of rationales as to why we cannot continue as we are, but rather to be prepared to supplant it with something in which the American people, of course, but just as importantly, members of Congress representing the people, because they're going to have to work with the next administration, every administration, and that relationship between the executive branch and the legislative has to be one in which investigations of wrongdoing shall be carried on without the heavy hand of Congress and without any sense of apparent or real conflict of interest that might appear on the other side of that ledger. So we're honored to have General Barr and General Civiletti with us. They know what we're talking about, and they also know what we don't know what we're talking about. And that's just as important. I hope that they will not fail to tell us that, that we're looking at this thing incorrectly, or that our proposed solutions are full of flaws, etc. But I, for one, am eager to hear the testimony. I'll yield to the gentleman from New York, who has now joined us, along with the gentleman from Arkansas, Mr. Hutchinson, and the lady from Wisconsin, Ms. Baldwin. We yield to the gentleman from New York for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, let me simply first express my appreciation to you, not only for calling this obviously necessary hearing, but for I had requested a little earlier this morning that in view of the fact that the Democratic caucus was going a little longer than expected, and that we had the Secretary of State there, that you delay the opening of the hearing, or at least hearing from witnesses, until the Democrats could get here. And I want to thank you publicly for that consideration. And in consideration of that consideration, I will not indulge myself with an opening statement except to say that I'm going to be asking questions of the witnesses partially based on a column in this, on an op-ed column in this morning's New York Times on this subject by Archibald Cox, the former Watergate, the special prosecutor, and by Philip Heyman, who was the Assistant Attorney General in charge of the Criminal Division during the Carter administration and Deputy Attorney General in the first 2 years of the Clinton administration. They make some interesting suggestions along the lines that the chairman was discussing a few minutes ago, and I'll be asking some questions based on it. I hope you gentlemen have read this column this morning. I yield back the balance of my time.
The gentleman yields back the balance of time. We recognize the gentleman from Arkansas, Mr. Hutchinson.
Thank you, Mr. Chairman, and likewise, I look forward to the testimony today and extend greetings to Mr. Barr and Mr. Civiletti. And this is an important subject. I think we all have our ideas out there, and I intend to ask some questions about different directions that we can take in regard to providing some independence for a special counsel who might have responsibility for investigation of an executive branch personnel or individual, but also listen to your ideas. So I look forward to that. And I also wanted to recognize Mr. Philip Anderson, a fellow Arkansan, who will be testifying in the second panel as president of the American Bar Association, and look forward to his presentation as well. And wanted to extend greetings to him today while I was up here. So with that, Mr. Chairman, I yield back, and I look forward to the testimony of the witnesses.
Can't you go on a little longer? I'm trying to hold a caucus here with my Democrat members. I thank the gentleman. I yield to the lady from Wisconsin. Do you have an opening statement?
Do you want me to wait?
Yes,
well, why don't you have the other Republican? Let's finish our caucus.
We did have Mr. Shabbat here before.
I could give my opening statement again, Mr. Gigas.
We'll recess for 2 minutes so I can get this little caucus out of the way. Recess having expired, we now have exhausted the supply of opening statements except for Ms. Baldwin, who will make an opening statement, and we so yield.
Thank you, Mr. Chairman. Just briefly, I'll share some of the reflections I did at our last hearing, which is that I have, along with the gentleman from New York, Mr. Weiner, a different perspective than most of the members of this subcommittee and the larger committee. I didn't sit through the last session and become intimately acquainted with the Special Counsel and Independent Counsel Act as other members did, but rather gained a perspective on the campaign trail, talking with citizens about their impressions and about, I think, a very serious fear that our system was in jeopardy, both from the perspective of what seemed to be unbridled expenditures and from the perspective of an ever-expanding jurisdiction. And it was communicated over and over and over to me during the last year that something had gone terribly awry. Now, there are many proposals, among them that we allow this to lapse. And what I want is to be able to provide assurances that if we do so, that those concerns of injustice will be addressed with that course of action too.
We thank the lady, and now we are prepared to, at long last, hear from our distinguished guests. To ruffle no feathers, we'll do it alphabetically. Barr and Civiletti, in that order. So, General Barr, please feel free to proceed. The normal rule is for the written statements, of course, to be accepted without objection for the record. The oral statements will be limited generally to 5 minutes, subject to the heavy hand of the chairman. so we now recognize the gentleman, General Barr.
Good morning, Mr. Chairman and members of the subcommittee. Thank you for inviting me today to provide my views. Is this on? Thank you for inviting me today to provide my views on the reauthorization of the independent counsel statute. I've been a consistent opponent of that statute and have continuously called for its non-renewal. In my view, the vices of the statute are inherent in the statute itself, the very enterprise of the statute itself, not in the way various independent counsels have handled their job. In that regard, I have my list of people who I think have done a good job and those who have done a bad job, and I'm sure each member of this subcommittee has their list, and I think our lists may vary. But in my view, the vice is inherent in the statute itself, and I don't want to canvass them in detail today. They have been, I think, masterfully canvassed by Justice Scalia in his dissent over 10 years ago, and I think when you go back and read that dissent, all of us should be impressed with his prescience and his handling of that matter. But what in essence happens under the independent counsel statute is you create what in the movie Dr. Strangelove is really a doomsday weapon. It's the legal process, the criminal process is a juggernaut. Let's make no mistake about it. And once you put that juggernaut on the track and start moving, it's very, very difficult to stop it. And what the statute essentially does is remove the discretion from people who should be in a position to supervise that process. And so it just carries forward a juggernaut to its logical end. So that it removes the perspective, the judgment, the discretion that should be built into prosecutorial decisions. Questions of proportionality, questions of whether alternative sanctions exist. If a government official, an executive branch cabinet secretary, abuses his frequent flyer miles, is that really something that may be a technical violation of federal law, but is that something that we're going to prosecute the person over, or are we going to require reparations, and if, significant venality is involved, perhaps resignation, and just deal with it that way? I've said publicly, accidental technical violations of campaign finance law, making a call from an office, not contumaciously, but unknowingly violating the law. Are we going to make a federal case out of that and prosecute that? Normally, those judgments would be made by a politically accountable official, and the juggernaut would never get started, or if it had been started, it would be turned off at the appropriate time. But I think the fact that we've created this doomsday weapon in the IC has had a number of consequences. Not only is it very unfair to the people who are in the crosshair, but I think it's contributed largely to the criminalization of our political life. And instead of having clashes over policies and philosophy, politics in large degree in this town has become a question of whether or not you can cast the actions of your opponents in a way that can trigger the independent counsel statute. And then you call the fire of the independent counsel statute down on your political opponents. Now, I have my views of when this game started and, who's responsible for it, but that's irrelevant. The fact is, that's what's now happening in our political process. And it's an unhealthy sign when we have all these legal pundits instead of people discussing policy. And we have editorial writers, opining as armchair prosecutors as whether certain conduct, could be viewed as a conspiracy or an obstruction of justice and things like that, because we have essentially used the criminal process as a political weapon. And I think there are a lot of reasons behind that, but one of the reasons is we have this weapon at hand. Now, another concern I have here is that this is all unnecessary in my view. There is an alternative to having a statutory independent counsel. And it's what we had in this country for 200 years before Watergate, and it was what we had in Watergate. And that is that the Attorney General does have the ability, in appropriate cases, to bring someone in from outside the department. And that's an important point to recognize. The choice here isn't between business as usual, that is letting a case be handled in the bowels of the Justice Department by nameless people in the public integrity section on the one hand, and bringing in a statutory independent counsel on the other. There are many cases, and probably most cases, involving executive branch officials are petty things that should be handled business as usual, you know, abuse of car or something like that, of your official car. But in those cases that the public does require some assurance that the matter is going to be handled professionally, without political influence, fairly, thoroughly, the Attorney General can bring somebody in that will provide the public with that assurance. And the Attorney General is the person that's in the best position to make that choice, because it's the Attorney General who is ultimately accountable and pays the price if it's a bad choice.
He's ultimately accountable, and what did you say?
Ultimately accountable for the selection of the individual and for the conduct of the investigation itself. Now, I would suggest that it's wrong to look for a foolproof method. Looking for a foolproof method, in my view, is foolhardy. We could extirpate crime in our society, or at least go a long distance, if we put a process in place that will detect and prosecute every violation of law. But will people want to pay the price of such a mechanism? No. We have adequate law enforcement. We can tighten it up a bit, put more resources into it. But we're not trying to create a foolproof mechanism. An adequate mechanism will do just fine. And I think it's the same with policing the executive branch. We shouldn't be looking for a foolproof mechanism that sacrifices all other values and interests, public interests, to ensuring that every potential violation is detected and tracked down and prosecuted to the nth degree. The price we pay is too high for it. It's unnecessary. We have gotten through as a nation without it. I shudder to think what Abraham Lincoln, how he could have managed the Civil War, or FDR managed the delicate process of moving our country into confrontation with the Axis powers, if he had an independent counsel hanging over his shoulder. We can get through this without a foolproof mechanism, and I think the price we pay in deterring good people from going into government service, we will end up with worse executive branch government because of this contraption, not better, because mediocrity will go into the system. People who need the jobs for some reason or another, or have nothing to lose. And also, I think, as Justice Scalia points out, in the timidity of the executive branch. We're in a situation now where no one wants to, use the lavatory without getting a legal opinion from somebody. That's how timid people are getting, gun shy, because of this statute. So I think the price we pay for this contraption is far too high. The Attorney General can handle these things under existing authority, and there's ultimately the political sanction to be used if there is an abuse of the office. And I'd like to see the watchdog institutions we have in society step up and perform the primary role they're supposed to, not let the independent counsel handle everything, but take the time when you're confirming public officials, like the Attorney General, or like the head of the criminal division, and every executive branch official, to really make sure we're putting people of integrity in those positions, and then continue vigorous oversight, both by Congress and the press. Thank you, Mr. Chairman.
We thank General Barr. We will now hear from General Civiletti, following which we will recess for the purpose of responding to the vote on the floor. General Civiletti.
Thank you, Mr. Chairman. Mr. Nadler, other members of the subcommittee, I thank you for the opportunity to appear before you and give you my views on this important issue, and I commend the committee and the chairman for its serious consideration of something that is not at all easy. I'm a trial lawyer, essentially. I've been a trial lawyer for 37 years, trying civil cases and criminal cases on both sides of the fence, plaintiff and defendant, prosecutor and defendant, and I've conducted any number of independent or private investigations and some public investigations where I've been engaged by the one form of government or another. One particularly, the House Judiciary Committee of the state of Rhode Island and the impeachment process of the Chief Justice at that time of Rhode Island. So my views are based and come so that I have full disclosure essentially from my experience as a trial lawyer and partly as my experience in 4 years in the Carter administration and the Justice Department. I have concluded, after myself experiencing appointment of independent counsel,
and also examining the 20 or so independent counsel that have been appointed, that the Act has structural flaws, inherent structural flaws, which make it undesirable, that it should expire, certainly should expire in terms of its present provisions. Essentially what it does, it creates, and was meant to create, a special situation. But what has occurred is that irregularity in the process, in the way in which the Act is triggered, in the time for the initial inquiry, in the 90 days for the preliminary investigation, it's created unequal justice instead of its intent, which was to create equal justice regardless of high position, and to make sure and assure the American people that investigations of high government officials were conducted fairly and with determination, and they didn't get any special biased kinds of breaks. But instead what has happened is that frequently the process of inquiry, report, determination of whether or not to appoint an independent counsel or request the appointment of an independent counsel converts what would in ordinary criminal proceedings be an investigation with little publicity into a hubbub of publicity, tainting the subject, creating a pre-bias before an investigation is even conducted, shifting issues to the nature, qualifications, basis of the independent counsel themselves, rather than the issue, once charged, is this person guilty of this crime or not? Another irregularity as compared to the process of the criminal law, and the criminal law ordinarily and regularly, regardless of how high officials are involved, a crime has occurred, or likely that a crime has occurred. And the investigation then goes about determining all of the circumstances of the crime and trying to find who the target is, or who the suspect is, or the best suspect, and to see if there's reasonable cause to indict, and then sufficient evidence to convict. But the Special Prosecutor Act, or the Independent Counsel Act, kind of reverses that process. And it picks a target and then essentially says, now what crime did that target, can we find a crime that that target committed? Another problem with the Act in a similar regard is that ordinarily in the criminal process, whether it's the Department of Justice or a state attorney general or a state's attorney in state proceedings, has a balance, limited resources, time and people and money, and therefore sets priorities and standards so that the most serious crimes are pursued first that harm the people the greatest, and minor crimes or lesser crimes are treated with plea bargains or non-prosecution or some other mechanism. Here we don't have that at all. There's no judgment, no predetermined judgment as a result of an office's or a national set of priorities, anything of the kind, so that there's no safeguard with regard to, as compared to the regular criminal process, there's no safeguard, and instead to some extent, and with some independent counsel, I guess, or the risk is, of course, that their success or failure depends upon their prosecuting any crime that can be found of any nature. That's a concern. Of course, the Act has worked reasonably well in a dozen circumstances, my guess is, where there have either been no prosecutions or successful prosecutions, and has worked more like the regular system. But in the other half a dozen or more investigations, without regard to the quality or conduct of the independent counsel, the irregularity of the Act has destroyed what would otherwise be known as due process. Now, my suggestion is that there is an alternative, and that alternative is the one that that Attorney General Barr referred to, and that's the Attorney General's power under, I think, Title 28, Section 600 or so, to appoint a special counsel, as Judge Bell did in about 1977 for what was known as the Peanut Gate investigation, where he appointed Paul Curran, who was a Republican U.S. attorney out of the Southern District of New York, did a superb job, concluded his investigation within 6 months, and that's occurred time after time, going back historically to the 1920s and in the 1950s in the Truman era, when IRS investigations and scandals were prevalent, all the way through Leon Jaworski. And as you may recall, and certainly strikes me because of its connection to Maryland, George Bell and the Attorney General's prosecution of Vice President Agnew at the time. So there is an alternative. It may have to be tinkered with. It has some of the same senses of irregularity, but not as many as the present statute. And it's far more or better subject to checks and balances and regularity than this statute. Thank you very much.
We thank you, General Civiletti. We ask your indulgence to remain in the chamber until we return from the votes that we have to cast on the floor, because we do want to ask you for your advice and for some answers to questions that are fomenting in the minds of the members. With that, we recess till 10 after 11. The time of the recess having expired, and noting the attendance of the gentleman from Arkansas, Mr. Hutchinson, together with the chair, the working quorum having been established, we will proceed with a round of questions for our distinguished panelists. The chair will indulge itself in, and allot itself the accustomed 5 minutes. General Barr, I was struck by the fact that you feel that you practically said that we ought to treat the allegations of wrongdoings almost on an ad hoc basis, not as soon as there's an allegation immediately go to the quick and see what kind of prosecutorial mechanism we can establish, but rather to determine in kinds of discretionary ways the severity of the allegation, etc. What was brought to mind immediately to me was the allegation against Hamilton Jordan of controlled substance misuse or something like that during the Carter administration. Of course, we should probably ask Mr. Civiletti on this, but looking back on it and showing learning of the quick disposition of that was a teapot, or one that didn't quite rise to the level of something that should have been investigated. Do you agree that that's the kind of original kind of discretion that ought to be applied as to whether a case like that should have been the subject?
About the details of that, yes. but that strikes me as the kind of case that could have been handled within the department. As I see it, there are cases that can be handled by career prosecutors in the public integrity section. But there are cases, and the political system will itself be the judge of which those cases are, which cases fall into this category, where the Attorney General, I think, should bring someone in from the outside that has independent stature, experience, a broader perspective, and sort of an independent power base, if you will, to supervise a case. And the political process will dictate when that's appropriate, and will also assure that appropriate people are appointed. So when Janet Reno appointed Fisk from New York, I thought that was an appropriate decision. I did this 3 times during my own tenure on the so-called Iraq-gate matter, which was a crock, and I didn't feel it amounted to something that an independent counsel under the statute should look into. Nevertheless, I brought in Judge Lacey. I had asked Attorney General Civiletti actually to come in to do that, but he was tied up on a matter in private practice.
He was impeaching somebody.
I also did it on the so-called Inslaw matter, which was even more of a crock because no one could ever understand what that one was about, but brought in Judge Bua to do that. These were all people, and then on the House Bank matter, Judge Wilkie. These were people who could come in and provide assurance that these matters were going to be handled without political influence. They conducted the investigations expeditiously, and carping did not disappear. They were still sniping, but basically the job got done and we moved on.
Now, you just reached out and found one of these individuals who was willing to serve.
Correct.
What do you think of the idea of having a kind of a board perhaps made up of American Bar Association membership or a special division of that organization to have a pool of people to whom the Attorney General can look for plucking 1 or 2 of them for these special tasks?
Well, I'd be opposed to that. I think it's an unnecessary embellishment in the sense that I think the Attorney General has to exercise their judgment and discretion up front as to who the appropriate person is. And frankly, someone who spent the time getting onto one of these boards, I wouldn't necessarily think is the right person to appoint for one of these things. But the Attorney General, I think, has to be ultimately is responsible for the decision that's made, and also for the ultimate conduct of the investigation. And therefore, I think the Attorney General should be able to pick whomever they feel is the proper person, someone who isn't going to be a headhunter, but at the same time, someone who will be thorough and fair.
Well, how did you get to Judge Wilkie?
Well, I knew Judge Wilkie. I knew General Civiletti. I knew, and when General Civiletti couldn't do it, I had heard about Judge Lacey. He had been supervising union issues up in New Jersey.
So you believe the Attorney General can simply, within its own discretion, the office look to the world of the bar and select judicious individuals?
Correct. I think it's a mistake to go to people who have one agenda or to create an office that has a narrow agenda. I believe the kind of person who should be supervising these cases is someone who has broad-gauged experience in the department, experience with the prosecutorial function, experience beyond that, and who comes in just for that assignment. Is still subject to the supervisory authority of the Attorney General, although perhaps not removal except for cause.
General Civiletti, what do you think of the proposition that we're contemplating of having, just as the criminal division head, Assistant Attorney General, is subject to confirmation, to have the chief of the, or not the chief of the public integrity section, but the choice of the Attorney General to head a particular investigation as special counsel, to have that confirmable by the Senate?
I don't think it hurts much. I don't think it helps much, because the head of the criminal division, which I was the head of the criminal division for about 1.5 years, really is the decision maker with regard to prosecutions and investigations. Ordinarily leaves it to the section chiefs, whether it's the fraud section or the public integrity section or whatever. But the Assistant Attorney General routinely and regularly has the authority to initiate, to insist on prosecutions, to reverse decisions, and that Assistant Attorney General is already a presidential appointee and goes through the confirmatory process.
The time of the chair has expired. We turn to the gentleman from New York, Mr. Nadler.
Thank you. I want to read some excerpts from today's op-ed piece by Archibald Cox and Phil Heyman and ask you to comment on that first. says the current statutes falls at twofold. First, politicians belonging to the party not in control of the executive branch are prone to demand the appointment of independent counsels for political reasons as bombs to toss into the ranks their opponents. Second, the relentless investigation directed at an individual, which we talked about before, talks about similar dangers would arise if we relied upon special prosecutors appointed by the Attorney General. So I'd like to get your comment on that. Then he says the best way to avoid these pitfalls is to assign the investigation and prosecution against high officials to a pre-existing permanent unit of government and to couple them with strong safeguards against outside influence. The most suitable unit is the criminal division. And then they suggest the following safeguards. One, that the decision of the Assistant Attorney General, whether they involve starting an investigation or ending one, must, with narrow exceptions, be final. Indeed, under Mr. Bell and Mr. Civiletti, all decisions concerning the prosecution of a particular case are ordinarily free from review, even by the Attorney General himself. Second, if the Attorney General believes a prosecution decision is plainly wrong, he or she should be able to reverse that decision, but only in the form of a public statement giving the reasons. It then says Mr. Bell strengthened the wall against influence by forbidding any communication about specific cases between prosecutors and members of Congress, congressional staff members, or White House officials. Any critical information could be communicated only to the AG or to one of the most senior deputies. This rule should be expanded in any case involving the President, Vice President, or Cabinet member to bar even communications from the Attorney General, Deputy AG, or Associate AG, except to convey information like the involvement of sensitive international relations. The rule would exclude from any role in prosecution virtually all Justice Department officials who might be personally or politically close to the President or other high-level officials on investigation. And one further safeguard for high-level cases, they suggest whenever the Assistant AG begins seriously to consider terminating an active investigation, he should be required to consult a panel of 3 of his predecessors, including at least one who was appointed by a president of the opposing political party. After that consultation, the Assistant AG should decide, but if he decides to discontinue the investigation without further action, he should be publicly required to state his or her reasons. Could you comment, do you think it would be a good idea to leave this situation to the criminal division with or without these safeguards? What do you think of these safeguards? And what do you think of the comment that a special prosecutor appointed by the Attorney General has the same basic problems as an independent counsel appointed now? In other words, maybe we should get rid of the special prosecutor appointed under Section 28(2), under Section 28, leave it to the attorney, to the assistant, to the criminal division with the safeguards outlined here, perhaps with some others. Could you just comment on both of them? Mr. Barr first.
I'm opposed to those recommendations, both elements. First, I think the supervision of cases should be done by someone who does not have a narrow focus, but is broad gauged, and not necessarily and exclusively coming from it from a position of prosecutor. All prosecutors have to be supervised, in my opinion, and therefore having
this doesn't leave them supervised by the Assistant Attorney General in charge of the criminal division.
I think the Assistant Attorney General is a prosecutor too, but requiring a unit with narrow focus and giving them ultimate responsibility, in my view, is not the way to go. And also, I think there are cases where you cannot count on the people in the Department of Justice, the line people, or even the Assistant Attorney Generals, to provide a level of assurance that that this case is going to be thoroughly handled. You sometimes get offices that go after people. Prosecutors are known to can sometimes become sort of headhunters. They get very focused, very vigorous and zealous. At the same time, I've seen cases where I think career prosecutors are trying to please their supervisors, maybe by not bringing a case or maybe by bringing a case. And I think ultimately they have to be supervised, and I think they have to be supervised ultimately by someone who has a broader agenda and is broader gauge than just someone in charge of public integrity. I think the idea of isolating and providing insulation for that reason is bad. In my own experience, I've seen line career prosecutors go after political officials of the other party, in my case going after high-level Democratic officials. I thought they had lost perspective and were on a vendetta, and I shut the case off. And I would shut the case off for a Republican if people objected to it and thought it was partisan. Let the chips fall where they may. There's a political process that imposes a check. But I would not say that just because a career prosecutor thinks something should pursue, we all should, take that as gospel. Look at Attorney General Reno's situation in the campaign financing. Now, she didn't bring a bigwig from the outside in. She brought in Labella, a career prosecutor from California, very highly regarded in-house guy. Now, she ultimately disagreed with his conclusion. He says you need an independent counsel. She disagreed with that conclusion and overrode him. Now, under this approach, in this editorial, whatever Labella said would be gospel. Attorney General.
No, she would be able to override him, but there would be another board that, and she would have to publicly state her reasons about all it says, really.
Mm-hmm.
Let me ask you just, the other thing I asked is, Cox and Heyman say that appointing a special prosecutor, even under the old statute, is still subject to the fact that politicians belonging to the other party are then prone, for political reasons, to ask for a special prosecutor to be appointed just as a bomb throwing. And second, the appointment itself and the formation of a special staff dedicated to a single investigation encourages the relentless pursuit of every avenue, however far afield, that might lead to the conviction of the high official. The almost irresistible tendency is encouraged by the fact that independent counsels have no way to demonstrate success or even to justify their existence except for indictment, impeachment, and conviction. And similar dangers would arise if we relied upon special prosecutors appointed by the Attorney General. Would you comment on that?
Well, first, that hasn't been my first, the device of Attorney General appointment goes back in history. It's what we've used up until Watergate. It was used in Watergate. So it's not as if we haven't had experience with it. And yes, there are times where issues become politicized, but it is not the automatic doomsday weapon that we see with the IC statute. And my own experience with direct appointments, I didn't have that problem. Did Bill Safire and other pundits attack me for doing it? Yes, but life went on. I survived the attacks. You're never going to satisfy everybody. And basically, fair-minded people on both sides of the aisle said, yes, we're satisfied this was a good investigation.
Okay, Mr. Chairman, could I ask you to consent for one further question?
Without objection.
Thank you. Mr. Barr, again, is it your testimony, then, that going back to the previous system, just getting rid of this statute, and do nothing other than what we had in the previous system, or is it your testimony that we should make some changes to the previous system?
I think there are a couple of changes that could be made to fortify the current Attorney General, the Attorney General's power. I know Congressman Hutchison was working on some proposals that would allow people to formally request the appointment of someone by the Attorney General and have the Attorney General explain why that was not appropriate. Statutory protection in terms of not being able to be removed by the Attorney General except for cause. And also there are issues of conflict of interest. When I went out to try to find people to bring in, like General Civiletti, to investigate cases or supervise their investigation, you run into conflict. The general conflict of interest statute makes it virtually impossible for someone to come in from practice. And that's why the current law deals with that in sections 594I and J. And I think that those provisions should be adopted to give the Attorney General more flexibility in going out and bringing somebody in. I think also you have to address the issue of attorney's fees. When the Justice Department investigates someone, generally they don't get their attorney's fees. Under the statute, there's a provision for paying people their attorney's fees if they're not indicted, and I think the committee should take a look at that issue, particularly where the thing being investigated relates to public duties. If the allegation relates to public duties, like in any corporation, if you're investigated and charged, the corporation will indemnify you for your official acts as long as they turn out not to be criminal.
Thank you very much.
The time of the gentleman has expired and expired and expired. We turn to the gentleman from Arkansas, Mr. Hutchinson, but we want to acknowledge the attendance of the gentleman from Tennessee, Mr. Bryant, the gentleman from South Carolina, Mr. Graham, the gentleman from New York, Mr. Wiener. And with that, we allot the customary 5 minutes to Mr. Hutchinson.
Thank you, Mr. Chairman, and grateful for the testimony of both Mr. Barr and Mr. Civiletti. I mean, I'm in agreement with your testimony today and the difficulties of the current independent counsel law. And so I want to focus on what we can do to strengthen the former situation with the inherent powers of the Attorney General to appoint a special prosecutor. Mr. Barr, I think you just outlined some suggestions that you had primarily to free up the conflict of interest provision, so it's a little bit easier to bring on someone in a special prosecutor role. You cited 954I and J. What, was that 28 USC or what?
I believe so. Wherever the statute is codified, I think it's 594I and J are the provisions that provide a specialized conflict of interest provision relating to independent counsels, and I think they should be carried over for whoever the Attorney General appoints. Otherwise, they're special Justice Department employees, and they're subject to all the, conflict of interest and post-employment restrictions and so forth that a government employee would be.
Mr. Civiletti, you made a point that I've made, and I think is what is very important, is that whoever the prosecutor is in a conflict of interest circumstance, whether it's independent counsel or a special prosecutor, that they have the ordinary and usual pressures upon them that serves as a checks and balance in our system. That they have other cases that they're handling, that they have other priorities, and they have to decide what the priority for prosecutions are, and it also are natural pressures not to extend an investigation too long. I think you phrased it in a different way, but I think we're speaking of the same thing.
Yes.
How do you, if you have the old special prosecutor law, how do you encourage those type of natural pressures if you appoint a special prosecutor?
If you're appointing an independent counsel under the statute, the only way to get something like a regular prosecutor's pressures and considerations is to appoint someone who has that kind of experience and knowledge and professionalism, so that you would hope that they would transfer that to the operation of the independent counsel's office. If you're appointing if the Attorney General is appointing under 28-600 a special counsel because of a conflict of interest that doesn't fall within the Act, or if the Act expires, then you can have a little more regularity, because there is although modest, a supervisory role of the Department of Justice over that special counsel, and you would hope, since it's an officer of the Department of Justice, that the person would become, if not already familiar, would become very familiar with the prosecutorial priorities, the resource
Let me ask you in a different way. Do you believe that you're better off having a special prosecutor such as Mr. Labella that has other prosecutorial responsibilities? I guess you could pull him off and say, this is your sole responsibility now to be a special prosecutor in this particular case. Or do you think they should have other responsibility, like pulling a United States attorney out who has other responsibilities, but he also has this particular case? Which one's a better direction to go?
It's a matter of balance. As Mr. Barr was saying, I think that it depends on the time, the nature of the case, the circumstances, whether you're better off with, for example, I appointed Dick Blumenthal as out of Connecticut as the special counsel for an investigation of leaks in the Abscam case. He was outside the Department of Justice proper, and had a lot of integrity, and was a former newspaper reporter, so he was ideal for that kind of assignment. On the other hand, Judge Bell appointed Paul Kern, who was in the opposite party, and for the Peanutgate investigation. So it depends on all the circumstances.
If you look at the current special counsel provisions and the inherent power of the Attorney General, I've suggested that there be a consultation provision for Congress, where Congress can ask the Attorney General that if there is a conflict, and we believe there's a conflict, that the Attorney General respond within 30 days as to why there's not a special prosecutor appointed in a particular circumstance. The second thing that I've suggested is that in the event a special prosecutor is appointed, that special prosecutor not be discharged except for cause, and that would assure some level of independence. One, do you agree with that? And secondly, are there any other tweaking that you think should be done for the special prosecutor provision that could strengthen it but still stick within that system?
I agree with the second point that you made with regard to the special counsel. The first point about, if I understand it correctly, about requesting the special counsel be appointed by the Attorney General, and then if the Attorney General resists, reporting to Congress as to the reasons for the resistance and so forth. I'm not much in favor of that, because by nature that becomes public, and the reasons for non-prosecution damage the individual anyway. Congress does not have prosecutorial authority. If Congress wants the Attorney General to, under certain circumstances, to appoint a special counsel, then don't request it or request a report. Say, you shall appoint a special counsel under these circumstances where there's a conflict of interest. In effect, take Title 28-600 and make it a mandatory statute that the Attorney General has to operate under law, or something similar to that.
Then you get into what triggers it and what level of proof. I mean, I would
Well,
hesitate.
what triggers it now is simply, essentially, conflict of interest that either pervades the Attorney General's office or pervades the Department of Justice.
Which makes the Attorney General politically accountable for whatever decision they make. Mr. Barr, do you have a comment on that?
Well, I agree with General Civiletti that I guess theoretically and in principle I'm opposed to the provision that sort of insinuates Congress into that role. However, as a practical matter, it's going to happen anyway. Committees, the Judiciary Committee particularly, will sign letters and petition for the appointment. That's going to happen. And excuse me. They don't need the law to do that, and basically they, hold their press conference, demand the Attorney General do it, and the Attorney General then has to offer an explanation to the extent they can, and the extent of the explanation is controlled by the political situation and the rights of the person, the potential target. So I think that in the real world, this happens and will continue to happen, and therefore, if Congress puts this in a statute, I'm not going to, have a tantrum over it.
Thank you, Mr. Chairman. I know
Time of the gentleman has expired. We recognize the gentleman from New York, or from Massachusetts, Mr. Delahunt, in the order of their appearance at this hearing.
Well, thank you, Mr. Chairman. And let me just at the outset say I really I tend to agree with both of your testimony. I think particularly as expressed by Attorney General Barr. In response to the questions posed by my friend from Arkansas and your suggestion in terms of the insinuation of Congress into this process, I think this to me strikes at the very heart of your statement earlier about the inherent flaws in the OIC statute now creating a criminalization of public discourse in this country. And I think you said in an informal way, this happens in any event. I think to create that insinuation in a mechanism which clearly and unequivocally puts Congress into the mix is a mistake. I also think, and I'd be interested in both of your opinions about the role of congressional oversight upon the conclusion of investigations. Might not that be beneficial? And in terms of this larger perspective, I think that you've been getting to, in terms of the flaws and the benefits of an investigation, and serving as a check on independent counsel potentially abusing their authority, or under the statute potentially abusing their authority, or not doing an adequate job. Isn't that, I don't know if you agree with me, but that's my opinion, the role of Congress. If a special, if under, whether statutory or whether under the OIC statute, there would be congressional oversight hearings into the conduct of the investigation once it has concluded, so as not to interfere. That serves, if you will, as a check on potential abuse, as well as assurance to the public that the investigation itself would be conducted in a fair but vigorous and an exhaustive fashion. Just a suggestion, and again, I have to disagree with my friend from Arkansas about putting in the statute congressional involvement along the lines that he suggested. Mr. Barr, Mr. Civiletti.
I feel that one of the casualties of this over-reliance on an independent counsel mechanism, and what I think is the criminalization of the political process, is that the institutions that should be our primary watchdogs have somewhat atrophied in that role. I think vigorous congressional role in the appointment process when they advise and consent on officials, and also in the continuing oversight function, and to some extent the media watchdog function have somewhat atrophied, and everyone sort of stands back in kibitzes as to whether particular conduct actually happens to meet a technical legal definition, instead of whether or not conduct, the impact of that conduct on our policies and on the polity. Now, in terms of the oversight after the fact, I certainly don't have any objection to Congress exercising that vigorous oversight after.
My sense is if that we did it, and if this statute should lapse and Congress exercised its this committee exercised its oversight responsibility, the abuses or the fervor of an investigation or lack thereof, if the special prosecutors or independent counsel, whoever was conducting the investigation and prosecution, would have that in mind if we exercised it. It would serve to, I think, subliminally to raise the awareness of those that accepted these very unenviable tasks that at some point in time they would have to answer.
When I was an assistant U.S. attorney in the early 60s in the United States District for the District of Maryland, we prosecuted successfully 2 congressmen for obstruction of justice for interfering with the investigation and criminal process. That probably tainted me at an early time to the view that the American people want a criminal justice system where politics do not determine whether somebody's prosecuted or not prosecuted. Right. They want it on the merits, fair and square. So that it seems to me the role of the Congress is to set the laws and say, here's what we think ought to be prosecuted and investigated, and in oversight, if your priorities are right or not right, what are your priorities, what's your success rate, why isn't it greater, but to avoid going into depth in individual cases out of the Department of Justice and putting career prosecutors at risk of their decisions by being second-guessed publicly in the forum. So I think you can accomplish the oversight. I would prefer it to be on a regular basis rather than oversight of independent counsel, because I think it doesn't matter much.
Well, if I get a little bit of time left, I think that, Attorney General Barr, I think you stated it really well. I mean, you indicated that you overruled or you shut down an investigation of an individual because you reached that decision. In the end, I think really what we're talking about is restoring confidence in the Attorney General to make those decisions based upon the tradition of sound, ethical, prosecutorial discretion and taking the heat. And that's really what it's about. And I'm concerned about possible tinkering if this statute should lapse with the statutory independent counsel and creating the same problems. In other words, politicizing it. Because over a period of time, as you gentlemen both well know, you in those roles, in your previous lives as Attorney General, are going to be measured during the course of time in terms of your integrity, in terms of your competence, in terms of your ethics, if you will. And I think we have to understand that that system worked and worked well.
Right. I think the important difference here is what are the consequences with a statutory versus an Attorney General appointed prosecutor? And you put your finger on it in this sense. Where political pressure builds on the Attorney General and there's no statute, the appointment isn't dictated by the statute, the Attorney General can either take the heat directly, because there's no automatic trigger that takes it out of the Attorney General's hand. Just say, this is nonsense. I'm not going to prosecute someone for this. Impeach me,
right.
Okay? And take the heat. Or if it's something like Iraqgate, where a lot of political pressure built up because it was an election year, then I felt that if I said no, then it was unfair to everyone involved because it would just continue to fester. And so I would look to someone like General Civiletti to come in, because he and I together could take the heat. And maybe enough people over here would say they're satisfied. But with the independent counsel statute, it's a juggernaut.
Right.
And the consequences aren't, no one can stop it and take the heat. The thing is launched. That's the consequence of having the IC there. So the price, Congress will always interfere. And the price you pay, though, with an IC statute is a juggernaut. The price you pay with the Attorney General doing it on their own is judgment, as long as you can take the heat. Whether or not you put it in statute that Congress can kibitz doesn't bother me very much, but I prefer it not to happen, but it's a little bit like saying, I wish it didn't rain,
Right. Or snow.
Right.
The time of the gentleman has expired. We turn to the gentleman from Tennessee, Mr. Bryant, for 5 minutes.
Thank you, Chairman, for a continuation of this very good hearing. And I thank the two distinguished gentlemen, including my former boss, Attorney General Bill Barr. I have looked back at this law and back at I guess the origins and the context of the day, and I think I agree with you this day that perhaps this statute is helplessly flawed, but looking back years ago, in that day, it was, I guess, the best thing since sliced bread. We had the administration, the president, the public interest groups like the American Bar Association, all types of people saying that we needed this. And then even as recently, I guess it's 1994, we had this Attorney General, Janet Reno, and this president saying that we needed it, and we reauthorized it. Something has happened, obviously, in the last several years that has at least given the perception that this IC law is helplessly flawed. I would suggest that what we have seen over the last few years, especially the last couple of years, through a combination perhaps of media and just the unparalleled scrutiny that we have today, particularly with television, 24 hours a day almost, analyzing, critiquing, together with different people with different agendas. For instance, a different level where the independent counsel has been attacked, personally attacked, without that counsel being able to appropriately and adequately respond to these attacks over a period of time. A sustained attack not only on the work that the independent counsel did, but the independent counsel himself. And I understand all of this is politics. I understand people have to keep their TV shows on. I understand people have to sell their products and things like that. And there are people who actually don't like being prosecuted by an independent counsel. But I guess we all agree that perhaps we can look back at the pre-existing law, and to me that seems to provide some protection, some insulation from some of this, because I think as General Barr mentioned, it comes down to that particular Attorney General being able to stand in the kitchen and take the heat in these types of situations, because you're always going to have the political power, political muscle attempting to take advantage of a situation. But now today we have the added scrutiny of the unbelievable media attention to these kinds of things. But if we were to go back, I think we have the power, the credibility of the Department of Justice and that particular Attorney General as a shield, again, as some type of insulation that could stand up a little bit better and to be able to handle that attack. Because I just think the situation as it exists now is probably unacceptable. I'm not inclined to want to reauthorize the law. I've thought about different ways, and I know my chairman is sending a letter forward to the Attorney General suggesting perhaps some further explanation of their testimony here. But it just seems to me once you've got someone who does not want to be prosecuted and who perhaps some of these ideas of term limits or limited scope or perhaps keeping the independent counsel in full-time position versus allowing them to go back and practice law would somehow move this process along, but yet we face the possibility of stonewalling and other issues. So I know I'm rambling here, but I am expressing my thoughts, and I think perhaps in many ways agree with your testimony that I think you're both saying this, you've looked at it, and the current independent counsel law cannot be remedied sufficiently. Is that correct, General Civiletti?
Yes.
General Barr?
That's my view, too.
Is there anything, I don't know, you've alluded to this, and I'm in another committee and in and out trying to cover both of these, but is there anything we can do to enhance the Department of Justice, the Attorney General's ability to handle these types of investigations, to, again, protect the Department of Justice, from these attacks of perhaps of lack of trust that's growing in society, and that there's a conflict of interest there and the Attorney General cannot handle this? Are there any other mechanisms, anything we can put in the law that would, and perhaps you could submit something later if you think of it, but have you covered some of these ways we can make these prior existing situations stronger?
I think Bill mentioned that the removal of the ordinary disabilities that apply to an officer of the Department of Justice for the special counsel enhances the opportunity of getting the right person to take those jobs if the disabilities are not so horrendous in terms of conflicts of interest or having to give up practice or whatever it happens to be.
Excuse me, that's 594 INJ you referred to before?
I'm sorry?
That's 594 INJ you referred to before?
Right. If
Thank
there
you.
are any other disabilities that they don't address, they could be expanded.
I would just say, in terms of strengthening the institution of the Department of Justice, I mean, you're never going to get away from occasional perceptions that it's inappropriate to let the department handle a particular case on a business-as-usual basis. In terms of building up the institutional capital of the department, I think Congress should be paying attention, a lot of attention, to who is confirmed for PAS positions and ensuring that quality prosecutors are being hired throughout the department on a nonpartisan basis. I also think, and I mentioned this in my statement, one of the reasons I'm opposed to the independent counsel statute is because on those few cases where that are very serious and should be handled criminally, and the dogs are on the trail and it could be the political fate of an administration, I think the independent counsel separated out of the department is too weak. They can be then attacked. They don't have the institutional basis to defend themselves. Think of what would happen in the Watergate case if Archie Cox was totally isolated, had not been selected by the Attorney General, and was under attack by Nixon. You know, Nixon may have been able to take the guy out. As it was, he had to decimate his own Department of Justice to take him out, and with big consequences for him. And so I think the appointment and the bringing into the department on a temporary basis someone to supervise actually, you know, from the standpoint in a good case or a case that should be pursued, strengthens the Office of Independent Counsel and ensures that it will be pursued.
I think if I might just make one quick comment to your last statement, think about what would have happened. I know there's some that would, in this room, that would disagree with me, but I think we have a perfect example of how it did work in this particular case, in the unprecedented attack on independent counsel at Counsel Starr. Thank you.
The time of the gentleman has expired. We turn to the gentleman from New York, Mr. Wiener, for 5 minutes.
Thank you, Mr. Chairman. And I would just say to my
my good friend from Tennessee, you don't have to look far to find someone who's changed their views on this issue, and part of that is because there has been, this is not the first time we've encountered the same problems that we're seeing today. And in fact, if you look at some of the transcripts from the hearings of the past times that we have reauthorized the act and tried to fix it, very, very similar debates kind of run through all of our consideration of this matter, and that kind of leads some of us to believe that it's fundamentally flawed. I was interested in hearing General Barr, you discuss the op-ed by Mr. Cox in today's paper. It seems like under the contraption that was created under his envisionment, you'd need almost Rube Goldberg to kind of negotiate the way through the maze, and I'm not sure that that deals with the problems either. Could you gentlemen respond to one thing that it's not clear that doing away with the independent counsel statute will actually fix, and that is this notion that has frequently concerned many of us that the direction of the investigations under the IC statute is upside down, that you are investigating a person rather than a specific act. And what wound up happening in the Starr investigation, to a lesser extent in the SB investigation, you started in one direction and wound up at the end of the investigation with an entirely different set of charges that were being brought. Would that be different under a special prosecutor if the Attorney General were left to his or her own devices? I mean, couldn't the same thing conceivably happen, that someone starts looking into something and then they lead off into another path, another path? Why would there be less of a problem if we do away with the independent counsel statute in terms of that direction changing in an investigation as it went along?
I think there are two reasons. One, the initial selection, and two, the continuing supervision. The initial selection, and that's why I think General Civiletti was absolutely right, in an individual case, the Attorney General is the one who has the incentive, the ultimate accountability of making sure the right person is handling that case. And that's why I say that it shouldn't be a narrow-gauge prosecutor, but someone who can bring general perspective to bear and say, wait a minute, this is nonsense, or don't get off onto that bunny trail. Because, you know, the basset hound, you know, following the rabbit has his nose down in the track, and you need to have someone who has a little bit more perspective. Sometimes tell them forget it. Now, so you have to pick the right person, and with all due respect, the panel, the judicial panel, has no accountability. If the thing, you know, people are not happy with what happens, they don't pay a price, and frankly, I don't think they necessarily have the experience to pick the right person, the right prosecutor. Enough experience supervising prosecutors. So as Attorney General, my feeling was, it's my obligation, and I'm not going to be happy with anyone taking that decision out of my hands. I'll pay the price if people don't like who I pick. And then the other reason is you have continuing supervision. If the Attorney General ultimately is willing to take the heat and say, you're not going to go down that bunny trail, they can make that call. Under the current system, no one's there to make the call. It's an automatic doomsday weapon. It just sort of goes along.
And in fact, there are many elements in the law that encourage a product to come out at the other end. So if anything, the independent counsel statute now kind of puts such a premium on getting something at the end of the day that I guess it encourages that kind of deviation from the original path if that first path seems to be dry. Yes, General?
There are two reasons why the Attorney General appointed special counsel is different in this regard than the Independent Counsel Act appointed by the court. The first is the Attorney General sets the scope, and sets the scope for the serious, necessary investigation where he had to recuse the Department of Justice, in effect, from doing it. Under the independent counsel statute, the scope is subject to the three-judge panel, and often the mistake, if it is made, is to err on the side of breadth rather than narrowness. Secondly, as the investigation is pursued, and suppose it's for bribery in the Department of State, and the investigator comes back and said, we didn't find any bribery, or we're still on the trail of bribery, but there were two assistant attorney generals, two assistant secretaries of state who've committed adultery. And, you know, that's a crime in the particular state. And so the attorney general then, or the assistant attorney general of criminal division, says, we've never prosecuted adultery in the Department of Justice. It's not a federal crime. What are you talking about? No, we're not giving you that authority. So as the suggestion is, the control mechanisms initiate and then subsequently are there, And there is the power, of course, of the Attorney General to expand the investigation by referring second matters or third matters that come up to the same special counsel.
I see. And General Civiletti, can you just respond to one other element of this that often goes without notice, but you did mention it in your testimony, and that is this, the way this thing takes on even a third life after the charge has been brought, it has been deemed to be not warrant further investigation or prosecution. Then there is this post-report that needs to be produced, which in many cases is a place where, frankly, damaging information gets dumped to Congress and dumped into the public domain. That it's frequently not discussed in this context, since there are many other flaws with it, but is that something that is usually done in prosecutions, that if a prosecutor says we're not going to bring this action, they would then submit a report saying here's all the stuff we dug up in the interim?
No.
And why was it that Congress included that post-report, if you have any insight into that? I mean, that seems like something you would only want if you wanted to support in a further prosecution.
It's not done in any regular investigatorial prosecutorial process. My guess is that it was suggested and then adopted by the Congress in order to have accountability, oversight, and a prophylactic effect if the special independent counsel knew that they had to file a report, that the care that they took in investigating and justifying their action would be greater. But it has the unintended consequence, most dramatically, I think most people would cite the Meese case and the second Meese case in the McKay report as being terribly damaging, terribly unfair, no opportunity to respond, and terribly troublesome.
Thank you, Mr. Chairman.
The time of the gentleman has expired. We turn to the gentleman from South Carolina for a period of 5 minutes.
Thank you, Mr. Chairman. A common theme here is the politicizing of potential criminal matters. When you're dealing with high public officials, I don't really know how to avoid that much, but I guess we can do a better job, at least try to. The appointing authority. What is more political? The Attorney General making an appointment of investigating, picking the person to investigate their potential boss or colleagues, or 3 federal judges? What is more political?
You could say that the Attorney General is political, but political in a good sense, because the only kind of accountability that's important here is ultimate political accountability. That's what the framers believed in when they talked about accountability, that the public has the ability to punish the person directly. And therefore, I believe appointments should be made by people who are accountable, and ultimately, someone who is accountable to the people through the political process should be supervising investigations. And the judges aren't, plain and simple.
Why wouldn't you want Congress more involved then? Because we're politically accountable also.
Because of the separation of powers. They are accountable for the legislative function, making the law. The executive is accountable for the execution of the law.
Well,
my response would be slightly different in that you can't isolate appointment by the Attorney General of a special counsel and appointment by the court of independent counsel, because prior to the appointment by the court, you may have 3 months, 6 months, 9 months of hubbub and publicity, or not even there should be a request for the appointment of an independent counsel. Whereas with appointment by the Attorney General, there may never be any discussion or public disparagement, and the Attorney General can simply appoint.
Item A in your, Mr. Civiletti, in your problems with due process says that the media and other public attention given to the issue of appointment or the request for appointment of an independent counsel itself taints the subject even before an investigation is commenced or charges filed. I don't see how in the world you avoid that. I don't care who does the appointing. If somebody's job it is to look at a person in high government office, why do you expect the media not to follow that?
Well, there are innumerable examples of the Department of Justice conducting investigations with grand juries of high public officials, not necessarily those under the Act, but high public officials about which there's no public debate, no public discussion until a charge is filed. Now, that should be the rule. There will always be exceptions, but that should be the rule and the standard that we're trying to achieve, rather than the reverse.
How much of the problems involved in this case flow from the fact that the person being investigated is the president?
I think a lot of them do, but...
Would it be fair to say if a grand jury was investigating the president, regardless how the appointment was had, that would be a significant media event?
Yes.
Is it fair to say, Mr. Barr, that Congress consistently oversees the executive branch in its role of being a check and balance on the executive branch through oversight, hearings?
That's a fair. I'm not sure what the point is, though.
Well, the point is that, to me, if you want to take politics out of the statute, ever who thought of 3 judges made some sense to me. And we're about to abandon that, and I know you've been consistently against this process, and I admire you for that. But there's a lot of this has to do with the fact that the subject of the investigation is the president. And we've got to understand that the defects in the statute...
Will my friend yield for just a moment?
Sure.
Lindsay? I mean,
Is the gentleman yielding?
Yeah, absolutely.
Let's try to observe the request for yielding.
No, I did. I made the request, and
Yeah,
I
all
saw
right,
the
proceed.
gentleman nod his head.
Absolutely.
And,
Absolutely.
yield?
I gladly yield.
but I would just expand the question. I mean, this statute clearly covers more than just simply the president, and I think what we've seen in the past, whether it was Iran-Contra, or, 20 independent counsels have been appointed. So I think in terms of the question, to expand that, the focus just simply on an investigation of the president, I don't think really gives a full, doesn't give our witnesses a full opportunity to respond to the structure of the statute itself.
Reclaiming my time, if I may. The point I'm trying to make is that the administration, the American Bar Association, and many people in the country came up here in '94 and said, we need this thing. The only thing that's happened since then is the investigation of the president. The reason that we have this statute to begin with is because what Richard Nixon did. When Richard Nixon was being investigated, he fired the folks, and we said, that can't work. Then we had an island of time of 2 years from '92 to '94, and people felt uncomfortable not having this statute reauthorized. And one of your criticisms, Mr. Civiletti, is that there is no qualification criteria about appointment in the statute. You don't believe it is sufficient enough in terms of having qualifications placed upon the people doing the investigating. Is that correct?
Yes.
Can you give me one example of a person you thought wasn't qualified who was appointed under the statute?
No, because I haven't based it on individual performances. None of my testimony is based on individual performances.
You just think
it's based on comparison between career prosecutors and the requirements of the statute.
In the Starr investigation, how many career prosecutors were on his staff?
I would guess a half a dozen.
Would it be fair to say that most of the people who did the work were career prosecutors?
I would say they did 95% of the work, is my guess.
Let's talk about scope for a moment. You start out with a land deal, and somebody gives you a tip that some of the characters involved in this case are about to commit perjury or obstruct justice in a lawsuit. Under your revision of this statute, would there be a mechanism to allow the independent counsel or special counsel to request to continue or to change the scope of the investigation?
Yes.
And under the facts of this case, do you think that was wise?
Yes.
Mr. Barr?
Yes, I do.
Okay. I think my time has expired.
But could I just follow up on that?
Yes, please.
I personally have the perspective, I share your perspective, that Ken Starr has done an admirable job. But that's not the issue here. The issue, it seems to me, is that...
Well, I'm not so sure that's all true, but I'm just saying that the problems seem to be with the focus of the investigation, the person investigated, more than the statute to me, but you've been consistent, both of you have, about criticizing the statute. And I admire that, but there seems to be a tremendous change. And when you look at the statute, the criticisms are real, but they're not penetrating to me, Mr. Civiletti. I think you're never going to avoid media involvement, regardless how the appointment is had, if it's a high public official. That the criteria for selection, the reason that we haven't had anybody you can appoint to, is because the people in charge of selecting have done a pretty good job. The 3 judges, to me, are less political than the Attorney General. I want to make it better, but I want us to be honest with the nation as to why we're having this debate now, not by y'all two, but by the Congress, and make sure that we don't overemphasize.
But Congressman, there are, I believe, as I said, that there are a couple of aspects of what's political. Part of politics is a good part, which is accountability. And I don't think having an investigation going on by someone who's not accountable and not selected by accountable people is a good thing. Second, under the IC statute, the politics, in the bad sense, make the fundamental intervention right at the beginning. And that is that you're heading down a criminal track right from the beginning. And that is where politics comes into play under the IC.
Now, tell me how that would, how's that so?
It's the hair trigger. It's the hair trigger. You know, yes, there are presidents that are investigated, but there are a lot of other people who are investigated for nonsense. It goes on 2 or 3 years when the thing could have been just dealt with in, a few days right up front. And they're not receiving the same kind of justice as other Americans, and that's because of politics.
But you're talking about stopping an investigation once somebody's determined, yeah, we need to look. You're talking about the politics of stopping and the politics of starting. Now, tell me how the politics of stopping can be improved upon.
I'm not sure I really understand what you're saying. What I'm saying is the decisive intervention of politics occurs under the IC statute when you start the juggernaut moving down the track, where that would not happen with Tom, Dick, or Harry. That's where politics comes into play under the IC statute, and that's why people are treated unfairly.
Well, I don't mean to belabor the point, but no matter how you start an investigation of a high public official, somebody somewhere is going to stop it. Is what you're saying, and you don't see a stopping mechanism in this statute.
I don't see, no, there's an automatic start, and there's no stopping mechanism.
Okay. And you're saying the Attorney General should be able to say that's enough and accept the political consequences?
I think first the Attorney General can make a decision whether something should even be handled as a criminal matter.
Okay. And, well, how does it work under our current statute?
Well, for example, if a cabinet secretary is accused of abusing something, a couple of $100 worth of government property, it's a federal crime, even though the guy can make reparation and in an appropriate case resign. That's nonsense.
How many nonsense cases have you been aware of under the
majority of cases that come up under this statute are of that type?
Are nonsense?
Yes, in my opinion, should not be handled under the independent counsel statute.
Why?
Because they can be handled up front with common sense and judgment. They don't merit 2 to 3 years of investigation.
Can you give me a list of those cases being provided?
Well, I can't give you a list of...
Not now, but just give me a letter about the cases you think were nonsense.
Well, I'll say, a lot of them occurred on my watch where, I was in an election year, and I was told I received more requests for independent counsel than all my predecessors combined. And they were against Republicans, okay? But I think some of the cases that are going on now are nonsense.
Okay. I'd like some examples.
I think the agriculture thing is way at, went way beyond common sense. Although, the prosecution of Durenberger, or the threatened prosecution of Durenberger, was excessive in my view as well. I think, spend 2 or 3 years to decide whether Cisneros, I mean, he obviously didn't tell the whole truth in the interview. Why spend 3 years on that? He's resigned. Those are 2 examples.
The time of the gentleman has expired, and the time of the committee has expired with respect to the votes that are pending on the floor. We are very, very gratified at your willingness to appear before us and to give your testimony. It will go a long way in the final decision made by this committee. As a matter of fact, in a sidebar conference held by the chair and the ranking member, we've already started to cogitate some of the proposals or comments that you have made. So we want you to leave this table knowing that you've made an impact on the process. We thank you very much. This committee stands in recess till 12:30, at which time I ask the members to please come back, Mr. Graham, to please come back, because the next panel contains one witness who has to be back in her classroom by 1. At the request of the ranking member, it's 12:35 to which we recess. We stand in recess. This afternoon, tell Ray.
We'll bring you the rest of this hearing on the independent counsel law in just a moment. Testifying, the president of the American Bar Association and 2 legal scholars. Coming up tonight at 11:05, a House Appropriations Subcommittee looks at funding for the Supreme Court.